Thank you, Mr. Neal. Congressional Republicans and the Trump administration have relentlessly tried to sabotage the Affordable Care Act. More than a year ago, House Republicans voted for a Trump Care bill that would have caused 23 million Americans to lose their health insurance coverage, increase the costs for everybody else, and resulted in worse insurance coverage than they have now. And in December, while passing a massive tax cut that overwhelmingly benefits corporations and the wealthy, the Republican Congress repealed the individual mandate penalty, which will allow healthy people to leave the insurance market and increase costs for everybody else. The administration cut funding for marketing and outreach efforts. Sick people do not have to be reminded that they need insurance. Healthy people might respond to that outreach, and so cutting funding for outreach will result in an insurance pool that is sicker and therefore more expensive. The administration cut off sharing reduction payments, which caused confusion among consumers, undermined market stability, and increased costs for insurance. It proposed expanding the use of junk insurance plans, where people lose their patient protections. It may be popular amongst some healthy people, but everyone else would be forced to pay higher premiums. The evidence of the administration's sabotage can already be found in New York, Oregon, Maryland, and in my home state of Virginia, where insurers are proposing double-digit increases that they attribute to these initiatives. But the most recent attempt to undermine the law may be the most reckless action to date. By asking a federal court to once again allow insurance companies to charge patients exorbitant premiums and discriminate against the millions of Americans with pre-existing conditions, the Trump administration is demonstrating the extraordinary lengths it will go to take away Americans' access to affordable health care. In filing the brief, the administration abandoned two of its solemn responsibilities. First, the executive branch's constitutional requirement to faithfully execute the laws, and second, its responsibility to act in the best interest of the American people. The administration's stance in this brief lacks any logical or rational legal argument about why the court should make such a radical ruling that would wreak havoc with our health care system. Unfortunately, even if the court rejects the administration's arguments, as it should, this action only injects into the health care system greater uncertainty that will drive up the costs for all Americans. I stand with my Democratic colleagues to call out the administration's irrational attack on patients with pre-existing conditions and one of the most popular patient protection provisions in the Affordable Care Act. Democrats will continue to fight for affordable health care and will demand the administration respect the rule of law. Thank you, and I yield back to the